care, Medicaid, nursing home type coverage, that's still going to be the local social services program managing that. Very important to remember is that Medicaid is the payer of last resort. If there's any other form of payment, it must be exhausted or used first before Medicaid will step in. Levels of Medicaid coverage: basic Medicaid, Medicaid home care. We're going to talk more about that tonight than I normally would. And then Medicaid chronic care. That's chronic care is typically envisioning nursing home care. And that's where most of the discussion tonight is on nursing home care and chronic care, with some change for long-term care based in the community too. This slide here is probably going to be the most important slide for this year, for 2021. So under COVID, due to COVID, starting back in 2020, the Family First Coronavirus Response Act, Department of Health and Human Services declared a public health emergency. And due to that public health emergency, they changed rules of Medicaid applications. Our best information as of today is that we believe that this public health emergency is going to be in place through the end of 2021. That could change, but that's the most recent information we have locally. Health and Human Services, the federal branch of the government, has said they will provide states with 60-day notice prior to the end of the public health emergency. Why do we care? Well, it's taken most of what the rest of the slides are going to be and kind of dumped it on its head. So the laws have not changed for what Medicaid is and how you get it. What has changed is really eligibility for last year and this year as far as what you need to supply to the agency. And first being, if you're on Medicaid, recertifications were being extended and they weren't requiring people to recertify. So we were extending eligibility. Secondly, when people apply for Medicaid for chronic care, nursing home level, and for community level, people are allowed to attest to what their assets are, test what their income is, sign the applications, sign the supplement A, that's the part for chronic care, nursing home, and not have to supply documentation. You're signing a sworn statement that this is what you have and we're proceeding, and that's all we need to accept. No 5 years of documents required through the end of this public health emergency. Today, I was speaking with our director of Medicaid, and she indicated that some counties are now requesting that individuals submit the documentation for 5 years. And they can't take adverse action if you don't, but they're requesting it. Because at some point you're likely going to have to submit it. We don't know how this is going to play out through the end of 2020. Once the public health emergency is lifted, what it's going to look like for recertifications, whether you have to then supply all 5 years or if attestation will stand for that particular application. So we're kind of in the gray area, but importantly, this slide is probably, again, the most important slide for tonight, is that the rules have changed due to the emergency. You can attest, and recertifications are put on hold as well and given extensions. Another big change was set to come into play for New York State too, and it was really set to hit in October. So federal law requires us to do that look back for nursing home care. Federal law also allowed states to require a look back for home care and other community-based long-term care services. So we're going to go over what those services are in a minute. So finally, in New York, in the 2020 budget, New York enacted community-based long-term care look back period. States, this will get covered too, what we can't require a look back for, and there's a list of what we won't require, but included in that is Medicaid for hospital care, acute and primary care. So we can't require a look back there, but we did enact it. Which community-based long-term care services will require the look back period? Personal care services, the consumer-directed program, that's number 2, private duty nursing, assisted living programs, adult day health care, managed long-term care programs, Medicaid Advantage Plus and patient plan enrollment, and CHAWS, certified home health agencies, and some limited licensed home care agencies operated by adult homes. So those are the programs that the new look back period is going to apply for. It would already be applying to, but for the public health emergency. So right now we're still kind of in the same pause due to attestation. Certain programs are not going to be required to have a look back, and I'm going to go through what a look back is and how it works here shortly. But programs that aren't included in the look back are nursing home transition diversion waiver program, the traumatic brain injury waiver program, waivers that are acquired through the Office of People with Developmental Disabilities, most managed care programs, and acute primary care in the community or in the hospital. And that was mentioned a little bit before. So we won't be looking for look backs on those items. So now, based on those changes, we'll talk about the long-term care look back a little bit, or the community-based long-term care look back later. But taking, again, this year with a grain of salt, what are the rules for covered for nursing home? Nursing home is the highest level of coverage, and it typically requires a look back for 5 years. And now, again, we have the community look back as well that we'll be phasing in. The Medicaid application process is driven by, again, it's driven by an application. And the application date is the date that the office receives the application from the individual. And this date's important because what happens is we get to give coverage is we can begin as early as the first month, 3 months prior to the application date. This is called the retro period. So if you apply, again, the example, May 28th of this month, 2021, and you're eligible, then coverage can begin as early as February 1, 2021. So we get to go back 3 months. So you don't have to apply. You can wait till you're eligible, and you get 3 months after that. We'll be able to go to the back to pick you up on that retro date. Typically, what happens when we get the application, someone in the office will be assigned your case, and you receive what we call a pending letter in-house, but it's really a document request letter. It will come to you or your authorized representative. Especially in COVID, we've no longer required, this has been going on pre-COVID, face-to-face interviews were no longer conducted unless it was requested by someone. Right now, the buildings aren't open and eligible. We're not able to accommodate that. We could electronically, we can still meet with people. Again, I started by saying Medicaid is really it's a low income based program. It's based on your financial eligibility. It's based on both income and resources, your assets that you own. And it's for the person applying and any legally responsible relatives. I know there's already been a question pending about spousal refusal. We can talk about that really at the end of the program too. But so you're going to have to supply documentation for income and resources for legally responsible relatives. And that will trigger what we're looking for. So the institutionalized spouse is someone that is in a medical institution or nursing facility, and they're expected to remain in the facility for at least 30 consecutive days. Or someone that is in receipt of home and community-based waiver services and expected to receive such services for at least 30 days. Or their active PACE. Again, PACE program of all-inclusive care for the elderly, or some combination of A and B. And they're also, because it's institutionalized spouse, they're married to someone who's not described in items A through D. So that's where the community spouse comes in. This is the spouse of someone that is on the previous slide, the institutionalized spouse. And there's someone who's residing in the community and not expected to receive home and community-based waivered services. So that's how we get spousal type budgeting for chronic care Medicaid. When we have a spousal case, individual is the spouse in the community. They are entitled to keep the MMMNA, the minimum monthly maintenance needs allowance. That's easy for me to say. This is the allowed amount that community spouse is allowed to receive in income each month. That's not counted against them, all right? Or they're entitled to that amount. And for the year 2021, community spouses are entitled to receive $3,259.50 per month. If a community spouse is receives over that amount per month, we do not ask them to contribute the whole amount towards their spouse, their institutionalized spouse cost of care. We ask them to contribute 1/4 of the income over this level. So any amount over the $32.59.50, 1/4 of that over, they're requested to contribute that to their institutionalized spouse. If, however, the community spouse has income below the minimum monthly maintenance needs allowance, the institutionalized spouse can contribute their income to bring the community spouse up to the minimum level. So if they had $3,200, the institutionalized spouse could contribute $59.50 to them to bring them up to that level. Net available monthly income. So this is for what we're going to tell the applying person, the applicant recipient. This is the amount the applicant is required to contribute towards their monthly cost of care. So we're going to request them to contribute the NAMI, and we call it NAMI, but again, net available monthly income. NAMI, if someone is single, so there's no community spouse, and permanently placed in a nursing facility, the NAMI will be the gross income minus allowable health insurance premiums. Will allow a deduction for cost-effective third-party health insurance or Medicare premiums, minus the $50 per month personal needs allowance. This part seems absolutely ridiculous to me. We allow the single person to keep just $50 a month. It doesn't really cover much. That number has not, all the other numbers really are kind of indexed for inflation and they change. Like the minimum monthly maintenance needs allowance is a new number for 2021. This $50 a month has not changed. Since I've known, I don't know when it was last changed. So that's all that person in the nursing home gets to keep. Everything else, that all their other income is going to go towards their cost of care. That's going to be their NAMI. So if you're single and temporarily placed, so you're in the facility, but you're not anticipated to be there permanently, then your NAMI will be the gross income minus the allowable health insurance premiums, minus the Medicaid level for one. So for the year 2021, you're allowed to keep $884. So if you're temporary placed, you'll have to spend down to this $884 as opposed to the $50. Now, if you're married, first the community spouse income is compared to the MMNA. And if the community spouse income is below that, then again, the institutionalized spouse can contribute to bring the community spouse up to that level, the 3259.50. So, and then the remaining income of the institutionalized spouse minus the allowable health insurance deduction and $50 is the NAMI. So they only get to keep the $50 after that. If you're married and the community spouse's income is above the minimum monthly maintenance needs allowance, we're going to request that 1/4 of that amount is added to the institutionalized spouse contribution towards the NAMI. So we would request the community spouse to pay towards the institutionalized spouse cost of care. So spend down is another term we use. It's the use of medical expenses to reduce the net available monthly income. Resources in excess of the medically needy income and resource levels. This is not available to all individuals. It's available only to those that are SSI related, disabled, or 65. So that's the category that is able to have a spend down. And what are we talking about with resources? So resources are all your stuff, your property of all kinds, including real and personal property. Now, certain items are exempt. There's allowable dollar amounts which the applicant they're permitted to keep and still be eligible. There's a resource level for 2021 that's $15,900. So that amount of money or resources, whatever form it takes, is $15,900 for this year. And again, resources can be spent down on medical bills to make yourself eligible. There's a couple other things that I'll mention that are exempt assets. Your home, if you have less than $906,000 in, so just short of $1 million in equity in a home, the house is exempt. A car of any value would be exempt as well. There may be an issue with a lien on an exempt resource such as the house, would be the house. We don't take liens on cars, but on the house we could take a lien. So that's the resource level for one person. Now spouses, again, we talked about spouses being able to keep a community minimum monthly maintenance needs allowance. They also get a community spouse resource allowance. For 2021, the minimum resource allowance is $74,820. And the maximum is $130,380. So depending on the timing of the application and what is owned or the placement of actually the person in the nursing home, you would be able, as a community spouse, you may be able to keep between $74,000 and $130,000. That'll be your maximum. And again, the house isn't counted here. And certain assets are treated possibly as income as opposed to resources, such as your IRAs and 401ks if they're in payout status. Snapshot. Snapshot is the date that an applicant is actually seeking coverage for Medicaid. So what do we mean there? So what we look at is the total amount of resources at the snapshot date. We look at the total amount of resources owned by the applicant and the spouse, if there's one. On this day, is calculated and compared to the allowable resource level. So those resource levels from the prior two slides, we're going to look at the amount owned at the time of the snapshot and then compare it to what the allowable resources levels are then. So then we look, I mentioned before, was the look back period. how long are we going to look back and try and determine what assets are there, and if there's excess resources. We're going to look back 60 months, 5 years for a look back period for all resources, including trusts and annuities. And again, this is the period immediately preceding the date that the person's seeking Medicaid. So preceding the application, the actual application date, but again, you could go back 3 months prior to that too. So actual date that they're seeking coverage. You don't have to go back to 3 months. You might not have a bill for those 3 months, but you can. That's the maximum you can go back. So look back starts from 5 years from the date of seeking coverage. The new community-based look back period is going to be 2.5 years, and that will be phased in over time. The phase in, again, we're not there yet because of the COVID public health emergency. So we're going to have 30 months and 60 months. So 1/2 the time period for the long-term care, community-based long-term care. In addition to resources, the county is going to request that you supply us with a resource explanation sheet. And what this is we require a written explanation of every deposit and every withdrawal into any accounts which have been opened within the look back period that are over $2,000 or over. So if we see withdrawals or deposits 2,000 or over, we're going to ask you to give the county, the Department of Social Services, a written explanation as to what that was for or where it went, or where the money came from. Documentation of the source of deposits and the reason for the withdrawals will be required as well. So that's an additional thing that we're looking at. And documentation can include deposit withdrawal slips, copies of canceled checks and receipts. For if it's a regularly recurring deposit that's over $2,000, such as your Social Security or pension, it's not necessary to document each deposit. What we will look for is your new Social Security statement that's going to show any new deposits if there was a COLA from year to year. So we're going to look for something just establishing it once. You don't have to re-show it for every month. And there may be a slide on this later. I can't recall whether I left it in. So that $2,000 or more, that's a framework for us. If we see in your monthly bank statements that you were taking out $19,000 or $1,995 every month, and we see that as a recurring pattern, we will ask about that too. It's just a guideline. It's not statutory that they're exempt under 2,000. It's just what we're going to require documentation on those. So one of the issues that comes from having that 5-year look back period, or soon to be 3-year look back period, or 2.5-year look back period on the community-based long-term care, is transfers of assets for less than fair market value of the property. That's why we have a look back. We're trying to see, they require us to look at any transfers that were done for the purpose to qualify for Medicaid, and that were transferred for less than the fair market value of the property. So if you transferred an automobile to someone for $200 and it was actually worth $10,000, well, there's going to be a transfer for the difference between the $10,000 and the $200. And again, that becomes an uncompensated value. This is the difference between the fair market value at the time of the transfer, less any outstanding loans, mortgages, or other encumbrances on the asset. So we don't say it's really the net value and the amount that you actually received. what a penalty period does is it creates a certain period of ineligibility for you. So the period of time of ineligibility for certain services under the program, because you made it's not a prohibited transfer from the standpoint that you couldn't do it. It's not illegal for you to make these transfers. It's just that when you make a transfer for less than fair market value, it may have a result on your eligibility. All right, we're not going to say you can't make the transfers, it just affects your eligibility. So penalties only apply when an individual is otherwise eligible and seeking nursing home care coverage. So this year, the big deal, I mean, we have a big change. We're making a look back period for long-term care-based services, community-based services. The other big change the last big change for Medicaid was in 2006. This is when the penalty period, the calculation was changed. It doesn't start until you're otherwise eligible and actually seeking nursing home care coverage. Again, this penalty is going to be just for nursing home care coverage for chronic care, but we're also going to have to change this for the long-term based community coverage too. So that will be factored in. And the penalty period is calculated by dividing the total uncompensated value of a transfer by the monthly regional rate. And the regional rate, again, unlike that $50 we talked about, changes every year. And it varies within the state. In New York State, there's 7 regions. For 20, we're actually in the central region. And the regional rate for the central region is $10,857. The regional rate used in the penalty calculation is based on the region the nursing home is in, that the applicant resides in. We're actually, so again, if an Onondaga County resident applies for Medicaid while residing in a nursing home in Suffolk County and Long Island, regional rate for Long Island would be used to calculate the penalty. Based on that, the penalty will be less or shortened because the regional rate in Long Island is larger than it is in the central region. Our region has the lowest regional rate. Again, New York City, Long Island, they're going to have the highest regional rates. And the way the penalty calculation works is you take the amount of the transferred value, the 50,000. So we're going to use 50,000 as an example, makes the math somewhat easy for me. So the net value of that transfer, that uncompensated value, 50,000, you divide it by the regional rate, which is 10,857 for this year for our region. That results in a 4.61 month penalty. So what that means is the person would be ineligible for 4 full months of nursing home coverage with a remainder penalty of $6,572 for the 5th month. So if there's a penalty incurred, that's how it's going to be calculated. Again, with attestation, due to COVID, if you attest that there's been no transfers in that look back period, there'll be no penalty incurred. Now you're still signing a legal document. If you attest to a penalty, then we will calculate it. So what should you do about Medicaid and planning ahead? Talk to friends, talk to family members, begin to gather all the information necessary in one place. Now, 5 years of bank records. Most of us aren't retaining 5 years. With electronic copies, it may be easier to do that, to start gathering documents. Again, for this year, you might not be required to produce them, but I can't guarantee when this is going to end. It will end at some point. We will have to start producing documentation. So it's better to prepare. So looking for, and again, with the community base now too, you're going to at least want to start collecting the 30-month look back period. So start collecting the documents. Considering appointing a power of attorney. I don't have a good reason for people not to have powers of attorney. I'm also the attorney for the county that pursues special proceedings when we think a power of attorney may have acted inappropriately. And that does happen. Power of attorneys are powerful documents. And so what a power of attorney does is it allows someone to make financial decisions on your behalf while you're alive. Power of attorney ends when you pass away. So the person being appointed as your power of attorney is technically not your power of attorney, they're your agent or your attorney, in fact, but it would allow them to assist if you became incapacitated. So power of attorney can be extremely important in a Medicaid situation, because if there's no power of attorney, who's going to be able to request and receive your bank documents if you didn't have 5 years in place? Who's going to be able to get information from your IRAs or your 401ks? So that's where the power of attorney becomes important. Having it set up properly and being mindful that it's a powerful document, and being mindful of what gifting authority you're giving to individuals is important as well. And I do recommend speaking to attorneys when they're signed. It can be extremely helpful because they are, again, so powerful. For the Medicaid process, again, it's an easier process right now from the standpoint of attestation and not having to provide 5 years of look back documents. It can be a long, involved application process. Nursing homes are aware that this process takes time. You'll continue to receive bills from nursing homes during the application, and these numbers can get large and scary, okay? But if the application is pending, they can understand and you're cooperating with them. And for many applications, the nursing home may be assisting you. But that's just be mindful that it is a process. When you're during the middle of your application, keep your Medicaid worker aware of any changes and where you stand with the information gathering process. If there's an outstanding pending letter, if you're required to get, and there's a due date on it, and you're not done with acquiring the information, make sure you're reaching out to the agency, to your worker. If they're not available, if you can't reach them, get a hold of the supervisor and ask it for an extension. It's important that you follow through on that. And you may be asked to provide proof of why you need the extension. If you've sent 2 letters to a bank and they haven't responded, let us know. Keep us informed so we can help you in that matter, because again, sometimes financial institutions aren't the most cooperative, but you need to keep us in the loop that way and make sure you're asking for extensions. What we have done, and again, this year, throw this year and last year kind of out the window, but we gave extensions without the need for documented reason, but that was resulting in longer processing time. And the state really requires us to process these timely, and it's a burden's on us, but what the regulations require is that the applicant recipient is the primary source of the information. So it's on the person applying to provide us with all the documents that they need, that we need. And we really started limiting the number of extensions that we give, just to be fair to the clients so that we could streamline this process. And again, if you fail to provide the documents, or if you fail to timely request an extension, or fail to give us a reason for needing the extension, we can deny the case. Again, we take this job very seriously. Onondaga County, we really do take the job seriously, and we will review everything that is submitted to us, and it takes time. Making sure the information is legible and complete as possible. Putting together a good application will ensure that it's processed quicker too. Because if we see other accounts referenced, if we see accounts income streams referenced on a income tax return, we're going to ask for documentation for that. We will look at this, we'll look at the information. We will ask you to provide documents. I did keep the slide. The $2,000 is the starting point, but the agency again has the right to request verification of any other deposits. Things to keep in mind during this application or prior to what you're doing now with your money. If you routinely mix money in one account between friends or family members, you may want to consider stopping that practice. We see a lot of clients that have added a child onto their joint accounts, made them co-owners. That potential, and maybe that child's adding some of their own money in and taking money out, that can be looked at as transfers. You're going to have to keep track of any of those type of transactions. If they're a power of attorney, just list that power of attorney and it's all your own money, that shouldn't create any issues. But again, depositing money from having your child put money in there and having them withdraw money, that can create penalty periods or transfers because we don't know where the money's coming from or whose money it is. And so you want to be mindful of that. Again, if you have someone that does not handle money and has another individual pay their bills and then reimburses them monthly, you want a paper trail. Just don't, it's going to create a problem for you. If someone operates just in cash and they give you the cash and then you run out and pay the bills, again, documentation is going to be very difficult. I know this. And for many people, they may be doing this and not have an idea that's going to create a Medicaid problem. Just for us to keep in mind, it can create a problem. And it has, and I've dealt with lots of cases that this has happened. And paper trails of expenses the person incurs for themselves. If there's a monthly recurring bill that seems out of the ordinary, if it's not labeled like their National Grid or something to that effect, they're paying a loan back, try and document these items. Or if they have a big purchase, they went out, they had to buy, repair a door or replace a door, or large utility or appliances were purchased. Keep track of those items, especially keep doing that ongoing for 5 years. Again, I just said that, save receipts for big ticket items and have them in a place where you can find them. Start making clear, legible notes on bank books. And again, we're seeing fewer and fewer bank notes for check registers because people are writing fewer and fewer checks. A lot more electronic transfers. And look at your ongoing monthly bank statements. Are they clear what they are? Because if they're not, you're going to keep an independent listing of those items so you can try and get back and figure that out. Medicaid rules are not IRS rules. Different IRA mandatory deductions and gifting. IRS allows a certain amount of gifting per year. It's not counted, it's not taxable, or you don't have to report it. But gifting, we'll always look at gifting as a potential transfer. It's not always. If there's a pattern of gifting, certain gifts are going to be allowed. Mandatory withdrawals on mandatory deductions for IRAs. For an applicant recipient, you're required to maximize your IRA distribution. And for most people, the required minimum distribution when you reach age 70.5 for the applicant is not going to be sufficient. We're going to ask you to take more out of your IRA. For a community spouse, if they are taking the required minimum distributions, if they're taking periodic payments out of an IRA, that will be sufficient. It will be counted as income. The IRA won't be a resource, it will be income. So that's in addition, when you might be thinking an IRA or 401k is a resource, if it's in payout status for that community spouse, it's not going to be a resource. What they receive will be counted as income and possibly need to be contributed. So that's retirement accounts are handled slightly different. If you're under 70 and a half and you're over 59, we're going to ask for you to start taking distributions, or it will be counted as a resource. So 70 and a half is a mandatory with distributions. Finally, if you don't like the decision that we've made, if you think we made a mistake, you have the right to a fair hearing. For chronic care Medicaid cases, I'm the attorney that sits across the table. Well, when we were doing these hearings in person, I was the person that would sit across the table and represent the Medicaid unit. But they're really they're not formal processes where you can represent yourself. You don't have to have an attorney. Most people do not have attorneys. But now they're all being done by phone. We're still conducting fair hearings. The judge is on the phone, the clients are on the phone, and the county representatives, the fair hearing representative and myself were on the phone as well. So what you want to do too is you don't want to miss, if you have a determination, you received a determination from us and you don't like it, don't ignore it. All right, look at your rights, your 60-day rights to file for a fair hearing. So your notice will have a date on it, and you will have fair hearing right notices on the form. You want to read that and comply with it. And I think that was the end of the PowerPoint. And I know there were some questions. And I'll stop my sharing of my screen.
Okay, thank you, Morgan. There's just so much information. It's unbelievable, and it's very difficult, I think, to take in just in such a short period of time. But we do have, anybody has additional questions, go ahead and either raise your hand or put them in the chat. We do have a couple of questions for you, though. The first one, since you just talked about it, Morgan, is about the 401ks or an IRA. And I think earlier you said that it is not an asset or a resource, but then I think you just wanted some clarity on what it is that an IRA or a 401k is as an asset or a resource, or is it that? There was just some confusion.
There is confusion because it's confusing. So it can be a resource. So, but ideally it's considered income. So if you're eligible to take deductions out of the IRA or the 401k, either the individual who's applying, the applicant, or their legally responsible relative, the community spouse. For community spouses, if they are taking periodic payments out of a retirement account, IRA, 401k, whatever it may be, it's not treated as a resource. It is treated as income.
Okay.
For the applicant recipient, it's the same. If they're eligible to take deductions or distributions from the retirement account, we're going to require you to do that. We're going to tell you how much you should be taking. You may already be taking assets out of it. If you're not taking enough, we'll direct you to take more out. But then it's only considered income. The balance is a resource. And at death, if you continue to have money in that account and there is a beneficiary on it, that money will pass to the beneficiary. There's not a lien on those assets.
Okay.
Hopefully that clarifies that a little bit. Annuities are handled a little bit different. Okay, if it's a straight annuity, a non-retirement annuity, we will request that the New York State be named as a beneficiary up to the amount of Medicaid being provided. Will be a secondary beneficiary if there's a community spouse, will be the primary beneficiary if there's no community spouse. So, and it's only up to the amount of Medicaid received.
Oh, okay. Okay, hold on. Now Tao's back. Okay, now speaking of liens, I know you just mentioned that. There's a question about somewhere back here, somewhere during the presentation, you mentioned something about taking a lien on a house that you may do. So the question is,
Yeah.
why or when would you take a lien on a house that's
So,
considered an
yeah,
asset, right? Or
right.
it's,
So it's an exempt asset, but if you're a single individual and you're permanently placed in the nursing home, it's not, your home ownership is not going to make you ineligible. You'll qualify for Medicaid, but the department will place a lien against your home, again, for the up to the amount of Medicaid that's received on your by you. So yes, you qualify for Medicaid, but you could have a lien against your property. So
is that
that
for a
which would,
single person, or if
so
there's
for a single person, that's the way it works. If
Okay.
there's a community spouse, we're not going to place the lien, okay?
okay, okay,
Or a disabled child, we won't do it then either.
okay. So if an individual, let me just posit this one. If an individual is not married, is single, and qualifies for Medicaid, but has a home, and then they rent that out, is that considered, I mean, and that rent would be income, but would they, if they were moving into,
Right. Because you may rent it, you may want to rent it so that so it can be maintained. Because if you're only getting $50 a month and you only have $15,900 in resources, how are you going to continue to pay the taxes? How are you going to pay the maintenance and upkeep?
right?
So if you have a rental, the net amount of the rent's going to be considered part of your income as well, but the lien's still going to potentially be there. So that's, I know that's, you think, yes, great. It's an exempt resource, but then you have to deal with the fact that there's a lien afterwards.
Okay. So next question is, can I sell my home to a family member for fair market value within that 5-year look back period and not be penalized?
Absolutely. So
Okay.
fair market value is never going to be a problem. The best indication, if I was selling it to a family member, what I would want for documentation would be I'd want to have something documented the value of the home, like an appraisal. Maybe a comparative market analysis, so you could at least document back to them that this is how we came up with the purchase for the purchase price.
Okay. And that could be an appraisal from realtors?
Realtors, so realtors will typically give you something called, again, it's a comparative market analysis. And many times they'll do that for free. Appraiser is going to, a certified appraisal is going to cost you money.
Okay. Okay, because yeah, I know realtors will do it, so, okay. Now, this question just came in, I'm not sure, is $884 the allowance amount for a single person household living independently?
Single person, correct. It goes up with each, if it's a two-family, that was just based for a single person. And again, if it's a chronic care coverage, then we get into spousal, depending spousal budgeting, so there could be more. But yes, 884 was the single person.
Okay, hopefully that will answer that. So I think that you answered this question sort of throughout the presentation, but the question really is, this is a professional person who works with clients, and they're always asking how the income and asset test is performed. And I'm not sure what performed means exactly, by you all, but does that make sense? Is there a process performed
It's based on the documentation that we receive, and that's where those pending letters come in, is that if we see other forms of income coming in, we're going to ask for documentation. So yeah, we're going to look at all the documentation that's there and compare them to the
Okay, so-
allowable limits.
Okay, so the income and asset test is really performed based on the documentation given you.
Correct. And what we request.
Okay. And then I believe, I believe within the body of the presentation, you did discuss what was countable income and assets.
Yeah.
And that would be, the process really is to provide that documentation to you, and then and that would be under review.
Right.
That would be the process. Okay.
And I don't have an issue. I don't know what your process is for, but you certainly can make this PowerPoint available to the participants today. That's fine.
Oh, yes, it'll be posted on YouTube, actually.
Okay.
So, and then the other question that I mentioned earlier was they asked if we could cover situations where folks have excess income but are trying to qualify for Medicaid. And they mentioned specifically pooled trust and spousal refusal. How that impacts their application.
So pool trust, the concept with the pool trust is that you'd make a contribution into a trust that is not just for you, but it's for a group, and the assets are pooled. And then as you submit, when you make those allowable contributions in the pool trust on a recurring basis, bills that you may have that you incur can be paid out of that pool, and it can avoid the spend down if it's done properly. Now the spousal refusal, New York State has not, it comes up in the budget every year that New York State could disallow spousal refusals for the nursing home care. What a spousal refusal is when the community spouse says, what I'm going to do is I'm going to provide you with all my income and resource information, but thereafter, I'm going to refuse to make any of my income and resources available to, or you can choose income or resources available to the spouse that's in the institution. So what that does is that will render your income and assets unavailable to the institutionalized spouse and make them eligible. So if you have a lot of income and assets, that may be a way to become eligible, have your spouse become eligible quicker. You must provide us with the documentation of the income and resources that you do have. And one thing you need to be mindful of is that creates an assignment by the institutionalized spouse to the county to pursue recovery from the community spouse. So if you issue a spousal refusal, spouse is going to become eligible, but that community spouse may get a letter from me that says, you've signed a spousal refusal and we're now looking for a contribution from you, either for the full cost of care or for an ongoing contribution of that excess 25% of income. So it will qualify the spouse, but it doesn't mean that you may not get pursued by the county for contributions. The benefit being, and you'd qualify at the Medicaid rate, which is going to typically be about 30% less than what the private pay rate is. So if you don't mind hearing from me, it may make sense. So hopefully that helps.
So hearing from you, Morgan, is that legally binding? So you would
No.
say, I'm asking.
No,
Go ahead.
Sorry to interrupt you. So hearing from me is going to be in the form of a letter, and say, we're going to request contribution. You could say, you can ignore the letter from me. What the potential that raises is we could bring legal action against you in Supreme Court or in family court if we're just looking for income contributions. You could negotiate with us, but we also look at it on a case-by-case basis. There are certain scenarios where it may create such a hardship for someone that they're not really don't have that many excess resources, that we could decide it's not worth our pursuit of that case. First, for an example, if we had a younger person that suffered a stroke, and they have a community spouse and they have younger children, and the spouse, despite maybe income allowances for family member, they need extra money. And that could happen. We could review those facts too.
Okay. Now, one final question on the pool trust. Is the pool trust you're able to establish within that either 5-year or 3-year look back and not be penalized? Is that something you can establish?
Yeah, once you become institutionalized over certain ages, or once you're in the facility, then after that point, we're not going to allow. But yes, in the look back period, it's not going to create that issue for you.
Okay, that can be done. That can be done at any time. Okay. And then so there is no longer an availability to provide gifts during that look back period?
No,
I mean, you can, but you might be penalized.
you might be. We're not absolutely going to, it's that we're going to look at it. Gifts, again, just because the IRS allows you to make a certain amount of gifts per year doesn't mean that it's not going to affect your Medicaid eligibility.
Okay.
Now, if you show to us that for the last 15 years, you've given your family members gifts of $5,000 for 15 years at Christmas, every year, $5,000 at their birthday, and you've established a pattern of gifting, we're going to look at that because you didn't do it for the purpose to qualify for Medicaid. Now, what I've seen and experienced is where people, maybe they did have a pattern of gifting, but the gifting pattern was $200 a year at Christmas. And then they got sick, and then they jumped it up to $10,000 a year. So that's where it comes in. Was it a pattern? Was it done for the purpose to qualify for Medicaid? How old was the client? That does factor in what is their health concern. I mean, were they in good health? Was it someone that had a sudden onset of an illness like a stroke or something like that, and they had no other issues? Or was it someone that knew they had early stages of dementia and then they started gifting their assets away? So, variety of factors.
And just 2 more questions on a legal standpoint. Is it perhaps, I guess, your recommendation that individuals who are looking to apply for Medicaid hire a Medicaid lawyer, or I'm not too sure what the lawyer would be?
Well, no, there's planning you can do. I never question someone that's going to get legal advice. Okay. I can't give you legal advice because I work for the county, but getting attorneys to give you legal advice or getting someone that knows what they're doing on this, my only position is that the rules, as you've stated before, this is complicated stuff. There's a lot of stuff to go through. So if you are hiring someone to assist you, I think it'd probably be in your best interest to hire someone that does this type of work and is familiar with the rules and how the application process works.
Okay, so this question, I'm going to add a little too. This is the final question. But if I have, for instance, hired an attorney to help, would they submit the application directly? So I wouldn't go through the county, because I know if I didn't want to hire an attorney, I could simply go through the Medicaid.
Yeah, I mean, that's up to you, and that's up to your arrangement with your attorney. I've seen both scenarios, but it probably whatever your arrangement and retainer with your attorney is on how the application process is going to work. Are they assisting you putting it together and then they're going to do everything for you? We've seen them where they applied on their own and then they hired an attorney for a fair hearing process. It's really, there's no special rules on that. It's what your agreement is with them.
Okay. So if somebody did want to apply for Medicaid, then they would just I should provide that information to where they would, who they would call.
Right, since in submitting it to the Medicaid office, correct? Yeah, I didn't, it's not,
Yeah, you know what, I will add that also, just so, I'll add that to the PowerPoint before well, I don't know how I'm gonna do that, but we'll provide that information. So, I do get people, often calling and asking me that at
for the address.
Yeah, it's just where to go. So, and I think that's it, unless anybody else has, got questions. I don't have any more here. And so I just want to say thank you to everybody who joined us. Thanks for your questions. I hope that you are going away with a little more information than when you came. As I said, it's a huge topic and it's very difficult to, to pack into a short period of time. And again, if you have additional questions, just reach out to me. We'll see if we can, have some of them answered. So, and Morgan, I can't thank you enough. I really appreciate your time. I
Well-
know you've had a really long day.
Well, thank you though for having me. I'm glad to
Yeah.
participate.
Oh, we really appreciate it. So thank you so much, everyone. We're going to end now. And again, this will be posted on the YouTube channel at Onondaga County Office for Aging. It'll be a week or two. I have to do some editing, but it'll be available for you and we can share the PowerPoint as well. So everyone have a wonderful evening. Morgan, thank you so much. Go home.
Thank you. Thank you. Take care.
All right.